Hello everyone and welcome to the third instalment of the UCC Law Society Solicitor series. Today I'm joined by David Sweeney and I would like to say thank you again to the Southern Law Association for their continued sponsorship of this series. So David, how are you doing?
Haley, how are you?
Not too bad. Do you want to tell us a bit about yourself and I suppose your career?
Well, listen, thank you so much for the invitation. It's great to be in here in possibly one of the most regal rooms I've ever been for a podcast. So this is the council room, is it?
Council room, yeah.
Yeah, no, I didn't go to college here in UCC. I went to UCD. Well, I was a registered student up there. I didn't really attend much back in the day. But yeah, no, thank you so much for the invite.
That's great to have you.
Yeah, so look, I am a solicitor. I also, in the last couple of years, became a notary public. So I qualified as a solicitor 2007, 2008.
Yeah.
And I suppose back then, when you train as a solicitor, I'm from Tipperary, so I trained in a small practice there in a general practice. So I kind of got, my training was in education and everything related in a small practice. So that would be conveyancing, probate, litigation, personal injury, wills, some family law, just bits and pieces of everything. I had really good training, a really good legal training. And then when I qualified 2007 and 8, the practice itself was predominantly conveyancing practice, which would have been property. Obviously the economy crashed. Yeah. There was no need for property solicitors in Tipperary, so I had to look further afield. I'd gone to college in UCD, as I said, and I just started to look south and looked at Cork. I got an opportunity to work in a firm in Cork, and I worked in a firm for about a year or so, and then I set up my own firm 11 years ago. And I started off in a little glass box on my own, and I kind of just worked, and we've grown now to 6 and 7 employees. We have an office in South Terrace in Cork. We've bases in Dublin and Limerick City. It's been an interesting 11 years, I think. Yeah.
Very good. Will you cut out the pause? Yeah.
Perfect. Yeah.
Very good. And I suppose your kind of predominant practice would be in medical negligence and personal injury. And how do you kind of find that? Do you like it? And I suppose any students that might have an interest in that in college or think they might have an interest in it, what kind of advice would you have for them on that side of it?
Yeah, so we're now a specialist personal injury practice, and we specialise in road traffic, slip and fall, workplace accidents, and also medical negligence. We predominantly specialise in birth injuries, and that would be birth injuries to the mother during childbirth. That probably, the specialisation came about maybe about 4 or 5 years ago. As I said, my training was kind of a general practice training, and most people when they start off as a sole trader, one-man band type legal practice, they end up being a jack of all trades and a master of none. And so you take on every bit of work you can get because, first of all, you're running a business. So I'm a businessman and I sell legal services. And you have to have that mindset all the time because you have to pay the bills, you have to pay staff, you have to pay your tax, you have to pay everything. You have to give yourself a quality life. And when you start off in business, it's hard to say no. And you think that you have to get as much business in the door all the time and the variety of business. And what happens is you dilute your knowledge, you spread yourself too thinly. And I found that then the service then isn't as good as it should be. And my training was a general practice training, but I just really like court. I really like, there's a buzz about going to court, the High Court especially. There's also, we're all serving people, and so our service is to help people. And you kind of have to be very empathetic and sympathetic to people over their own personal issues. And a lot of those people in personal injury and medical negligence have gone through a stressful time. So either something happened to them, whether it was a one-off event or a process of misdiagnosis or whatever it might be. So you kind of want to know, you have to be able to help people first. Obviously, I'm running a business, and I just really enjoy that part of it. And then when you specialise and get more narrow down your field of what you want to do and the service you do, you get better at it. Yeah. You get way more better at it, way more specialist. It takes a lot of time to learn it. It's not an overnight process. For example, a medical negligence case, the average lifespan of a med neg case from when the client meets you to when you actually set it or go to court is probably 4 to 6 years. So that's a long time to actually work a case. As a business model, it's not great. It doesn't work. That you take on a great, potentially big client, but you don't get paid for 4 or 5 years later. But that's just the nature of it. So what is a litigation solicitor? What does a personal injury solicitor do today? Say for example, someone's in a road traffic accident and someone's been rear-ended, and say in that accident they've been pretty moderately injured where they maybe broken their leg. So that person would obviously be treated at the scene, they'd go to hospital, and then if they weren't at fault, say that person's a passenger in the car, they realise that they may have a claim for compensation. So they'd contact the solicitor's office, they would arrange the first consultation, and the solicitor then makes a decision on that day whether they want to take the case. And so how will someone take on a case? Well, one, the person has to be hurt due to the negligence of someone else. So there's a standard of care here, and has that fallen below. When someone's rear-ended, it's nearly de facto if someone's driving behind you that person is at fault. There's one or two exceptions to it, and then you as a solicitor decide whether you want to take that case. And that case is obviously. There's a lot in the news in the last 12 months about compensation culture and solicitors taking on claims, and we'll talk about that in a minute. But if you so wish, but when you take that person as a client, you as a solicitor believe in them. You believe you can help them, and you can believe you can get them suitably compensated for their injuries. And that doesn't just mean a compensatory payment for their pain and suffering. That means that person might be out of work for 6 months. That person might have to left college for a period of time. They'd have loss of earnings. They'd have medical expenses. The full ambit of recovery, you have to make sure that you can recover for them. And then the actual compensation payment itself, that's done. We've all heard about the Personal Injury Assessment Board, and then the recent guidelines changes that have changed, and the changes have been quite dramatic. But you would take that person on as a client, and then that client then engages in a process. Yeah,
and I know you kind of highlighted there the two things: compensation culture and the kind of changes at PIAB. And as you said, massive changes. I know you kind of spoke about them yourself before as well. How have you felt? Have kind of those changes impacted and improved or reduced, I suppose, the compensation culture, or do you think there still is, or was that ever even a thing, I suppose, the compensation culture?
Well, you've got to ask yourself who's benefiting. Okay, first of all, let's take the compensation culture. Is there a compensation culture in Ireland? I don't think so. I think if someone is genuinely injured, they're entitled to take a claim. The courts is there, the law is there to protect them. If someone has a loss of earnings, is badly injured, they should be compensated. They should at least have recovery of the money they may have lost as a result of someone else's negligence or the pain and suffering someone else caused them. Now, I'm obviously only talking about genuinely hurt people who are honest in their endeavours and they're honest in taking a claim. Of course, there's people out there taking false claims. Of course, in any profession, there may be solicitors who are, I won't say promoting false claims, or maybe exaggerating them, I don't know. But then the flip side of that, it's the solicitor's job to get full value for their client. So if that client needs further medical assessment, if that client has, and I find a lot of the time when you're meeting with a client, it's an Irish mentality that a lot of people don't exaggerate the claim. They don't actually like telling you how badly they hurt. And then sometimes you might have a client for 6 months and they actually tell you, well, I have mental health issues because of my accident. I've been taking days off work because of now I have depression or I have some kind of stress-related anxiety due to the accident or the injuries and the result that has impacted on my life. It's the solicitor's duty then to make sure that person is referred on to get maybe a psychiatric report or some kind of assessment. And if there is a mental health issue that has been caused as a result of the accident, the solicitor has a duty to add that then in the claim itself. And in some cases, a psychiatric injury, I don't really like using psychiatric injury because it sounds a harsh word, especially in I suppose the culture we have today where people have stress and anxiety all the time, and sometimes the stress and anxiety has been caused by the accident. Sometimes those symptoms or sequelae from the accident are worth just as much, if not more, than a physical injury. And it's the solicitor's job to make sure they get full value and represent their client as best they can. But to answer your question, is there compensation culture? I don't think the propensity to take a claim in Ireland, in my opinion, has not increased or decreased over the last number of years. I think if accidents happen because of bad road users or accidents happen because low health and safety standards in premises that are causing slip and fall accidents or whatever it might be, they've been going since day one and they will continue to do so.
Yeah. Perfect. So I suppose the question a lot of students might have is, how do you actually take a claim? If you do suffer injury, what is that kind of process like?
Yeah, well, as I mentioned earlier, the first step is meet a solicitor. See if you have a valid claim, and the solicitor will make a decision there and then on whether they want to take it on. And the first part is that you must lodge your claim with it's now called the PIAB, the Personal Injury Assessment Board. It was the Injuries Board for a while. It's had a couple of variations, but this was an independent body that was set up in the mid-2000, 2004. This kind of compensation culture thing is kind of cyclical. This body was set up in the mid-2000s. What it did was for a number of things. Number one, it meant that all personal injury claims must be lodged with the Injuries Board. So what that does, it took all the weight of the claims from the court. So previous to that, every claim you ever had went into the circuit court or the high court or sometimes district court, depending on the jurisdiction of it or the level of the claim, and the courts were just overwhelmed. Just the volume of claims just got too much for the courts to deal with. Second of all, the Injuries Board, because it was an independent body, it did any kind of fraudulent claims. It was just another barrier you had to go through. So it did wash out a lot of fraudulent claims, took a lot of the work out of the court system, and then it became a cleaner system of how claims are valued. So they brought out this book of guidelines, the book of Quantum, which is a guideline of how you value claims. So that's the book that's now been redone due to the new guidelines that came out in April 20 this year. So back in 2004, the Personal Assessment Board came out, and basically you complete two forms. One is the Form A, and that's the details of, so if you come into me and you had an accident, hopefully you never have, but if you were to, we'd fill out your details, and that's just your personal details, the date of the accident. And why that's important is the statute of limitation when you take an accident. So you must take your claim within 2 years of the accident, or within 2 years of the injury from the accident, or in the case of a medical negligence, slightly different. You can take a case within 2 years of the knowledge of the injury. So just say, for example, you had an operation that went wrong, and in some cases people have implements left inside them, and just say you didn't, the operation was in a certain date in July, and you went back in September, and they realised the implement was still inside you, whatever it might be. That's when the time, but maybe that's an extreme example to give, but you get what I'm saying. It's the knowledge of the medical negligence that might be there. And then we would then put on the Form A, which is the application for the Injuries Board, the person who we say is responsible for the accident, a slight description of how it happened, and then the description of your injuries. But that then is backed up by what's called the Form B, which is the medical report from your doctor. So would it be your GP, or if it's a consultant A&E, or whoever the first attendant that you saw, and then that's lodged in the Injuries Board. Now, why that's important is because, as I said, you have 2 years to take a claim. But when the claim is lodged in the Injuries Board, the clock stops. So just say you had an accident in March this year, you met me in July, and so 6 months have started running on the clock of your statute of limitation period. When you lodge the claim with the Injuries Board, you signed it, we dated it. It's actually, the system has changed now. You don't even have to do a physical form, you do it online, so you don't have to sign a form anymore as the applicant. But when it's in the Injuries Board, the clock stops. That's really good, because then as a solicitor, you don't have to worry about the clock ticking in the background all the time. So it's in there. So the Injuries Board then assess the claim. They've about 10 months to assess the claim. So what they will do, they'll first of all review it, see if it's an actual valid claim and they're happy with it. And then they will then write to the respondent, or the person who we say is responsible. And previous to that, we'll also give them what's called a 10-day warning letter. So we will have written to the respondent directly. And then the Injuries Board, they give them about 3 months to assess the claim themselves. Generally what happens then, the person, if it's a car accident, they would pass that to their insurers, and then the insurance solicitors or the insurance company themselves will either deal directly with the Injuries Board, or in the last 18 months, what I found, they've started to contact the solicitors directly to see if they can settle cases quite quickly, depending on the nature of the injury of the person or the claimant who's hurt. Once then the claimant's insurance company have decided to engage, so they will pay a fee to the Injuries Board. I think it's €850 for the actual Injuries Board to actually take on the claim, and then the Injuries Board will assess the value of the claim. So they will use, historically they would have used the Book of Quantum from the mid-2000s, and they would send my client, the claimant, whoever it might be, to their own doctors for independent examination, to their own consultant, depending what it might be, and then they will put that information together, and then they will then assess the claim. They give an assessment. So they write to me as the solicitor for the applicant or the claimant, and then they write to the other side, and then they say, look, we think this claim is worth €12,000. There's loss of earnings here of €2,500, and your medical expenses are included. So the claim is 14,800, whatever it might be. So within 28 days, then we have an opportunity, we can accept that. So what I would generally do at that stage, I would send that PIAB assessment to a barrister, so a special personal injury barrister, usually a junior counsel barrister, and they would then give an opinion. I'd ask for what's called an opinion of quantum, and what the barrister is asking there is that we would give him a brief, the full file with all the facts of the case and all the information we have, and I'm asking he or she, that barrister, to say, if this case was to go to court, what do you think we would get? What would a reasonable judge on a reasonable day give this claim if these same facts were presented to a judge? And then the barrister would come back and say, look, the accident happened at this stage now, it's 18 months ago, the client recovered within 12 months. They had this injury here. If this was to meet a judge, I think this claim is worth somewhere between 12 and 16,000 euro. We've been offered 14 or 12 and a half plus the specials, what they are called the loss of earnings. So more than often not, we would then accept that claim, or we would advise the client it would be our recommendation that that assessment could be accepted, except that that assessment is also sent to the defendants and they can accept it. They might think it's too high, so they can reject it, so both parties have to accept it. So we send back within 20 days, we accept it, they send back within 20 days, they accept it, and then that money is paid from their insurance company straight out into our office, and then we pay the claimant. So that's if it's accepted. If either party reject the claim, then they go straight to court, and then that's the court jurisdiction is determined by the amount of the claim. So the circuit court has a jurisdiction up to 60,000, and anything over 60,000 is into the High Court. And so if for whatever reason we reject it, we might think it's too low. So say that barrister came back and say, look, I think that claim is worth €28,000. We would say, look, we can't recommend you accept that award at this stage of the process. We would reject it. We then send the barrister a new brief, and we get the barrister to draft what's called the civil summons. So in that type of case would be a circuit court summons. The junior counsel would draft it. Once he drafts it, or she drafts it, the barrister, we send it to the client to review it, and then we must get the, I must go back and say about the timeline. So if we've rejected a claim, the injuries board then, or the person issue what's called an authorisation, and that means is that the clock is back on. So remember I said previously that maybe of the 2 years, the 6 months is back, but you get an extra 6 months grace for going into the injuries board, so you technically have two and a half years. But once they issue the authorisation, the clock starts ticking, so then you're back to your original 18 months, and then plus the 6 months grace that the injuries board give you for lodging the claim. So once the barrister has drafted summons, the client has confirmed it's accurate, we then must lodge the claim with the court. So you send it into the court, and you have it what's called stamped and issued. So you pay a court fee, which is €130 for a circuit court summons, and that's just the stamp duty on the summons, the court application fee. Once it's come back out of the court, then issued and stamped, we then serve it on the other side. So you have to go back to the original defendant, you serve it on them by registered post. If you can't find them, you'd have a summons server issued them personally, and then that starts what's called the pleadings part of the process. And the pleadings then is it's the over and back of the court documents. So at that stage of it, the defendant, we have to serve them originally personally the summons to prove to the court that they were aware of the action. They will pass them to an insurance company, they will nominate a solicitor firm, and then that solicitor then they submit a document to court, what's called an appearance. So the appearance means that there's a solicitor officially on record, but it also means that if there's a time period within which, once we have a summons issued, the clock stops. The statute of limitation period is now, it doesn't matter. You can actually buy an extra year if you want, so you have 1 year to serve a summons. So sometimes you might take on a case and you're not sure if it's a really strong case, you might have to get another medical report in the case of a medical negligence case, but the clock is ticking. You could have your summons, what's called a holding summons. You can have it issued and stamped, but you don't have to serve it for 12 months beyond that time. So you can actually, in that timeline, you get your expert medical report from the UK or wherever it might be. So once the solicitor has lodged, for the defendant's lodged their appearance, that means that we can't do anything without their knowledge, and the court knows that they're on record. There is a time limit within which you must lodge your appearance in 28 days of serving the summons, and that also means if the appearance is not lodged in 28 days. Now, the 28 days is a loose guideline that's strict, but you would never do it to a colleague if there's someone on record. If you knew someone, you'd always extend the time or allow them some time to put it in. But if someone wasn't engaging with you, if you knew someone had the summons and they were serving and were just had their head in the sand, you can go to court for a motion to take judgment in default of appearance. And that means then you can get full value of your claim in front of a judge if they believe that the other side was served correctly, but they haven't engaged personally or with a solicitor, and you can take up judgment in what's called default of appearance. So then once they lodge their appearance, the other side then, we will take it now that the defendant has been served correctly. The defendant passed to an insurance company, they nominate a solicitor, and the solicitor lodged their appearance in court. They're now allowed to ask questions on the claim. So we can't just say, look, your client caused this, and this is where we're holding them responsible. Or someone says our guy had a broken leg, it's rear-ended, you're driving recklessly, you're over the speed limit, whatever it might be. They're entitled to question all of that. So the questions they're entitled to raise are called particulars. So they give us a document called a notice particulars, and then we must go through each question. The notice particular kind of have everything from 20 to 70 questions on it, and it would all be about. Sometimes they question, they might want your previous medical records, maybe you have a history of broken legs, maybe you have a history of claims, all that stuff comes up in the particulars. So once we reply to their particulars, we formally, the client would fill it out with the barrister. The barrister would what's called settle it, which is completed. We send replies back, and then that document then is supported by the client's affidavit, which means everything I say is true and honest. And they actually would have done the same when we actually would have lodged or served the original civil summons as well. So the other side are entitled to look at our questions. They're entitled then to raise further questions, which are called further particulars, and then we can go back again and ask. We must answer the other questions, and then once the questions are all answered, then we're entitled then to get their defence. So the defence is a very important document, because once their defence is lodged, that's the last document in the kind of the pleadings process. So once they lodge their defence, and their defence could be, some parts of the defence will say, yeah, look, he broke his leg. We're not going to argue that the leg is broke, but we are going to argue that was your guy. We say he wasn't wearing a seatbelt. You know, so each claim is different. It's very subjective. So once we've replied to their particulars, they lodge their defence. Once they lodge their defence, then we're entitled to serve. Well, we would then, in a circuit court case, we would get the brief again for the barrister with all the pleadings, and we send it to the barrister, and we get what's called an advice and proofs. And the advice and proofs is a pretty lengthy document that the barrister will put together, and that's your checklist for going to court. So the barrister would say, for example, I need a statement from the client. I need a statement from any witnesses. We need an engineer here. We need someone to go on the scene and make sure that they've taken photographs and given an engineer opinion on if it was a car accident, how the car accident occurred, in their opinion, who was at fault. They would also need the medical evidence. So maybe if you broke your leg, you'd have your orthopedic consultant. You'd have your GP who first saw you. You may have the A&E surgeon or A&E consultant who met you at first aid, and your GP may have taken care of you for 6 months. And then the consultant orthopedic maybe had to get a bone fused or something like that. And then maybe, of course, there's a psychiatric injury that you might have got a consultant psychiatric report to base that on. So the advice and proofs is all in there. And then there's procedural stuff, a notice to produce. So that means that we're asking the other side to produce all the information that you're going to rely on to court, so we can see it beforehand. And there's a kind of a side avenue process then, it's called discovery. And discovery is that we want to see, now it's generally, well, it depends. Say, for example, it was a workplace accident and you slip and fall. Say, for example, you say we're in a meat factory and you slipped in the meat factory for whatever reason, or how it might have happened. But say we want to see the health and safety manuals for the meat factory. We want to see the health and safety procedure for that day. We want to see the health and safety procedures of recorded accidents for 6 months before our accident, just see its repeated behaviour. And generally, if you ask for it, they will say no. So we must go down the discovery route. So there's different categories of discovery that you can request this information under. And then if we feel that we need this information to support our case and they've been unreasonable in withholding it, we can take a motion to court for discovery. So discovery is kind of this avenue that goes off from your original claim. You go in front of a judge, tell the judge, look, we want to see, has there been accidents in this factory in the last 3 months? We think we should have the health and safety records and whatever it might be, the health and safety reports, whatever the daily documents were that might support it, and the judge might grant, look, yeah, okay, I'll give it to you for 1 month, but previous to the accident, you're not going to get 3 months, and that's kind of how that works. Then we get our discovery, and then once we have discovery and the barrister's happy that all the other checklists is ticked off, then we serve what's called a notice of trial. So now notice of trial is that we go back to the court system that we originally had our document issued and stamped when we paid the €130. That would have been given a record number. We go back to court then, and this pleadings process takes about 18 months. So it doesn't happen in a couple of weeks or a couple of days. It's kind of a lengthy process. You can see if you're over and back that amount of correspondence and there's a client and barristers involved and solicitors, there's a lot of engagement, a lot of work in a personal injury file. So once we have a notice of trial, we lodge back into the court, and then that just goes into the court system, and then you just go into a queue and you start your wait then for your case to reach the top of the queue, and eventually then you might get heard. So once you go into the notice of trial, that period, you're probably looking a year from then till you actually get heard in court. Sometimes the defence, once the defence is received by the other side or lodged, it's a good time to settle the case because all the legal work is done. You know, there's nothing new going to arrive up between the defence or that part of the case and the actual hearing itself. Sometimes insurance companies will contact the solicitor's office direct to see, and they have what's called without prejudice negotiations. And what without prejudice negotiation means is that, so say you act for the insurance company and I'm a solicitor acting for a plaintiff, and you contact me and say, look, David, I want to talk to you about the claim. We think the claim is worth €26,000. And I say, I go back and I have a look and I talk to my barrister, and generally the barrister will conduct that. So I would pass the file over to the barrister and they would conduct directly with the insurance company or the sister insurance company. And then between the jigs and reels, to come back and they say, look, we think the claim's worth, my guys think the claim is worth 34,000, and we settle on 34, we think we'll accept 34 and they won't come up to it. The most they'll come up is 29 and the client wants 34. So those talks just fall away and they stop. But without prejudice means that, just say we then go to court in 10 months' time or 12 months' time, none of us can stand up in court and say, well, you offered 28,000 a year ago. So it's without prejudice. We cannot, none of that, it's all confidential, it can't be released to the public, and you can't rely on any of those conversations in court to say, well, look, you admitted that a year ago when you offered 28,000, or you could say, look, well, you were going to take the 29, so that's, nobody can be prejudiced. So they're confidential discussions. They happen at various stages of the case. As I said earlier, it's more common now, they're happening at the very start, because the insurance companies realise if we can kill a claim and settle it at 3 to 6 months after the accident, we don't have to engage the solicitor and pay the solicitor to defend the case all the way out to the court. It generally happens then at the defence stage because the legal work has been done, and then you always hear about cases settling at steps. Like that happens depending on the defendant. In most cases, if you're suing a slip and fall type case for a city council or county council, they'll never settle early. They don't like to encourage settlements. You may get a settlement out of city council or county council on the steps. That means that morning, and a lot of that would be to do with they may not want the public to know areas of the city may be defective in the footpaths or cobbles or whatever it might be, and for other reasons. That's not the only reason, but that does happen. Yeah. So kind of like, I probably spoke for a lot there, but that's kind of from you walking into me as a client to you then, when you serve notice of trial, you go in, and then you go in front of a judge, and the day you're courting in the circuit court, we appear with the client, the judge is up front, the judge's staff, the registrar is just underneath the judge, he or she. The solicitor comes in, they face out, the barrister stands in front and faces the judge, so the solicitor prepares the case. So we prepare a file for court, we'd have like 3 or 4 copies of everything depending, and that would be the pleadings, the medical reports, engineer reports, the loss of earnings, the discovery, whatever it might be. If you go to the High Court, you would have 2 senior counsel with you. So a senior counsel is a barrister who has at least, they call it taking silk, so you're 20 years as a junior, then you become a senior. Most High Court cases would have 2 senior, so you have 2 senior counsel barristers, 1 junior counsel barristers, you'd have myself as the solicitor, and then the client is there, and then we'd have all our witnesses. Sometimes you need to bring your doctors to court. Now, because of COVID, and the courts have just opened up in the last few months, which is great, and it's really engaged people to get a lot of work done, but they're not encouraging witnesses to come to court for COVID reasons. So what you can do there, and what generally happened was, you would agree your medical reports. So if I have a doctor's report to say that you broke your leg, can't really bring in a doctor to say that the leg's not broke. Someone might say it's not as bad as it is, that you might have recovered in normally 6 to 12 months and you might have injuries 18 months. But most sides would just say, look, we'll agree to medical reports, and when that happens there, and both sides present their medical reports, hand them to the judge, and the judge will read them, and they'll make their own opinion on whether and who they want to believe or whatever. And then the judge then will hear the case. The plaintiff presents the case first. Our plaintiff will give evidence, and then we will go through all our witnesses. The defence might bring evidence. They might have their own engineer to say if it's slip and fall, the footpath was fine. I had a case there last week in the High Court where the barrister was saying that the footpaths are a very dangerous place. So you must be very careful, because they would say that a lot of slip and falls are what's called contributing negligence. So the person who had the accident should have been taking more care. And in reality terms, how contributing negligence work is that if the judge said, look, yes, I agree you had a slip and fall, you're badly injured, you probably should have been taking more care here. Maybe you're contributory negligent to contribute a fall of 20% of your injuries. So if you're awarded €10,000, they would take 20% off the claim. That's how contributory negligence works. And then when the court makes a decision in the circuit court, everybody accepts it. It becomes a court order. You have an opportunity to appeal it to the High Court, and then you would get, as a plaintiff, you get your compensatory payment, which is it's called general damages, and you also get special damages, which is refund of your loss of earnings, which are your medical expenses, anything related to the accident that you had to pay out, taxis, whatever it might be, and then your legal costs get paid as well on top of that.
Very good.
So that's it.
Yeah, very good.
Just like that.
Yeah, so it's all very very interesting, and I think you kind of touched on a lot there. PIAB has kind of streamlined a lot, took a lot of cases out of going to court. Really, have you kind of found that? Yeah. Yeah,
like PIAB is brilliant. It's an independent body. It's excellent. It's a very efficient body. Now there are a couple of cases that were historically excluded from PIAB. They generally wouldn't take psychiatric injury because they
kind of pure psychiatric injury.
Yeah, it might be a bit complicated for a quick assessment like that, and then also any kind of complicated injury, like someone had some kind of profound injury out of an accident. The PIAB generally wouldn't have done that. But the new guidelines that were brought in this year have kind of allowed PIAB now, they will assess some type of psychiatric injury. So over the last probably, I would think, 18 months, I think there's been a lot of propaganda from insurance companies over the cost of insurance and insurance premiums. Now, I get it. If you're a business owner especially, and you have to pay a premium every year to an insurance company because someone took a claim that ended up in false or exaggerated claim, and your insurance company pay out, and that in turn then was reflected in your premium, I completely understand that. I run a business myself, I get it. But I don't see where, in real terms right now, the new guidelines come in April. Insurance companies lobbied politicians, they lobbied the government, the law has been changed. Where is the reduction to the end user, which is say for example, the driver of a car? So I don't know if you drive a car, you're insured to drive a car. Has your premium come down this year?
Not a whole pile.
No, zero. It's not. There's no knock-on effect, or the end user is not getting a benefit here. Yeah. So who's getting the benefit is the insurance companies. And if you look at the Oireachtas committee hearings last year, and I'm not political, I'm not affiliated to any political party, but I think it's Pierce O'Doherty for Sinn Féin. He gives a talk. He was asking questions to representatives of the insurance company, and he was asking them about the amount of claims going down. They've actually all have been going down anyway. And the question he asked was, because he was able to give facts on figures of the amount of claims between a period of time around 19 and 20, I think it was. I don't have the exact figures. And he asked, when those amount of claims come down, can you show me where the premiums went down? And coinciding with that was that insurance companies' profits went up. So that's in his, you can see it on YouTube. And I think that's continued. So I don't see the premiums being reduced. Like solicitors are car drivers as well. Solicitors pay premiums. Solicitors they don't want premiums to go up as anyone. But solicitors have to represent clients. And as I said, we have to get full value for our clients.
Yeah, and I suppose, is there anything you can see that might be changes that could change that? Or is there any kind of changes in the law that you would like to see in the next?
Yeah, I don't think people get enough. I think the compensation should be more. People look at England, but who says that that's right? Who says the English system is right? Who says you should be paid small money for an accident? Who says that? Who says the English system is the correct system or the barometer that we should be judged on? I do think, though, that when a case goes to court, I have a lot of faith in judges, especially if there's a false claim. To bring a false claim in Ireland, you have to go through the injuries board, you have to go through a solicitor, go through the injuries board, then go through the court process, and then go through court and have a judge question you. Judges, they're judges, the experience they have and the knowledge they have and the wisdom they have. If you're there watching a live court case, you can go, like a lot of the court cases are open to the public, and how judges make their decisions. You can't. I don't see how you could actually bring a false claim through the courts. But yeah, so and the flip side of that is also they make sound decisions, judges. So they do. Now I would say they should give more compensation. They kind of get it right of what a client or what a person should be, a plaintiff should be entitled for their injuries. Yeah. What was the question? What would I change?
Yeah, if you could bring maybe any changes, as you were kind of saying, the premiums haven't really changed, even though the kind of.
I don't think there's anything I would change personally, because we just have to deal with it. We just react to the changes. And what is probably going to change now is that this is a prime example of someone hurt in a car accident that had like a whiplash type injury, maybe a back and neck, recovered within 12 months. Previously, that claim was probably worth, depending on the injury, recovered in 12 and 18 months, somewhere between 8 and 20,000 euro. That probably would have been the level of compensation that on the book of quantum on the injuries board. That claim now seemingly is worth about 3,000 euro, 3,000 to 5,000 euro. So as a solicitor, I don't know how you can, if you take fees out of that and work a business out of that, and it doesn't become practical for a solicitor to take on those claims. So I think you're going to see a lot of those claims reduced. I don't think people are going to take on those claims, or maybe they become lay litigants themselves and do the application to the board themselves.
I think that's really a good way for it to go, or is that maybe a flaw, that maybe something that shouldn't have happened? As you said, it's kind of devaluing, I suppose, these injuries for people. It's
certainly devaluing the effort and the work and the experience a solicitor gives in helping a person. Because yes, you can be a late litigant, you can be a late litigant in any court and defend yourself or take a case on behalf of yourself, but you can't beat an educated and experienced and professional solicitor. They're there on your side, they're going to give you advice, but that solicitor needs to be paid. If there's no value in the claims, they'll just disappear.
Yeah. And then kind of, I suppose, for students, if a student might have an interest in this kind of area of law, or think they might have an interest, want to know more, or what kind of skills would a student want to have if they were going to work with someone like yourself?
Yeah, that's an interesting question. I think there's different types of solicitors as well. You can be an academic solicitor, which means you love law and you love the academia of it, and how laws are made and how laws are created and how we all abide by laws, and how then you can be, I think one of the main skills, I think, to be a solicitor is you need to be a good people person. I think you need to listen. I know I've spoken a lot here, but part of the skill is you need to listen to your client. You need to really make sure that they're being serviced correctly and they're being represented correctly. The law is it's a great career. It's probably like, because I run my own business, I've taken a different route. It's a fine career to be a solicitor and be an employee. Absolutely fantastic. I would think also that, and I have my own podcast as well. I think we might have spoken before. It's on my website, SweeneySolicitor.ie. It's called The Sweeney Show, and I think I haven't done one in a while now, but we might start doing them again in September. But I suppose the last 20 podcasts I've interviewed solicitors, and I kind of asked these questions as well. You know, what advice would you give to a young solicitor starting out? And the majority of them say really enjoyed their job. The majority say it's a challenging job, it's interesting, it's quite varied. But most have say try everything at the start. So if you're a law student and you want to go into into your Blackhalls, or if you're King's Inn, go into a barrister, as a solicitor, the general practice route at the start is quite good, because you get a taste of everything. You get to see your employment law, your family law, your litigation, your probate, your conveyancing your property, whether that's commercial property or residential property. And then you might see, you know what, I really like conveyancing. I really like residential property. I really like an old registry of deeds title from 1890 in Cork, and all the complications that might have gone with that, and someone's trying to resell that house now that hasn't been sold in 100 years. And you might then specialise in that, and then you might find a practice or a solicitor that will give you great training in that, and then you just develop your own skills. But it's like everything, you got to make the most of it. It's a tough job. You have to work really hard. It's not so much the hours, it's the intensity that you have to work at. Sometimes I find when you go into work, it's like if you're in college, it's like doing an exam every day. It's like there is that pressure on you every day, because there's a lot of information. There's a lot of pressure. You're taking a case in the High Court, and someone's been badly injured. There's a responsibility to make sure you do that job correctly. Yeah. And yes, sometimes I do say it's like doing an exam every day. It really is. So you think your college exams, what you have every semester, you just transfer that into a work pressure. But that's just reality. The more you do it, the more you get used to it. I'm not saying it gets easier, but you get to know the process, and you get to know the system, and then you just educate yourself. You know, it's very enjoyable. It's a good career. I think. For me personally, I think as long as you're happy what you're doing, it doesn't matter what your career is or where you are living. If you can wake up happy, I think you're winning in life.
No, that's great, and great to shout out the podcast there as well. Definitely have a
thank
listen
you.
to that. Yeah,
Sweeney Show. It's on SweeneySolicitor.ie, and the website, actually we put a bit of time into it last year, the year before. Specialising in personal injury, medical negligence. There's actually a lot of information on it. If someone wanted to know about personal injury claims or med neg claims, there's a couple of really prominent, really good medical negligence solicitors in the country. I'd love to be in that tier someday. That's where I want to be. And that just comes from hard work and putting in the time. There's no shortcuts. And look, thank you so much. I really enjoyed my opportunity to be here. And if anyone wants to reach out to me or any student wants some help, email me at david@sweeneysolicitor.ie, or you can find us on Instagram, Facebook.
That's great. Thanks a million, David. And thanks a million again to the Southern Law Association, our sponsors. And stay tuned. You might have more of these. Thank you.
Thank you. Cheers.
Thanks, David. That was great.
All right.
Yeah, it was excellent.
You've been listening to the UCC Law Society podcast series, one of 3 coming out over the next few weeks. If you have any suggestions at all on how we can improve the show, we'd love to hear from you. You can find us on Instagram, Twitter, LinkedIn, if that's what you're into, and our website, ucclawsociety.com. If you ever want to come on the show, that's absolutely no problem at all. Do get in touch with us though, and we'll catch you next time. Thanks so much.